Good morning, everybody. Welcome to this session on international law and the Trump administration, part 2. This is the session on international trade and investment. I know folks are still joining us, but perhaps they can filter in as we begin. I don't want the panel to lose even a minute on this important topic. I am Mark Agrast. I'm the Executive Director of the American Society of International Law, and it's really a pleasure to welcome you. I hope that you're having a good experience at the annual meeting. We're sort of at the halfway point now. And again, this is the second of 3 programs on international law and the Trump administration. I think you can imagine that when the annual meeting committee began work on putting this meeting together about a year ago, neither they nor we nor perhaps anyone else could have foreseen the changes that would come, that would confront international law and international institutions after the U.S. elections. Both the committee and the leadership of the society felt that it would be very important to take account of all of this and not simply proceed with the meeting we were thinking of having, but to adjust our plans and consider this new legal landscape that we were facing. And this has taken place, as I'm sure you've noticed, throughout the annual meeting, through our keynotes, through the various programs that were already scheduled, but also and particularly through these special programs that we have added. Some of you, I think, participated in yesterday's late breaking panel on the Syria strikes. So we are trying to make sure that international law and the international and our society remain engaged and relevant, whatever may come. So again, this session is on trade and investment. This is part of an initiative that I hope you've been tracking over the past whatever portion of the first 100 days of the administration we are in. As the administration started, we also started a new public engagement initiative, of which this session, these 3 sessions, are a continuation. They consist primarily outside of the annual meeting context of a series of live webcasts that are available free to the public. They have been featuring former senior administration officials of both parties. And the idea of those sessions is to inform the broader public about fundamentals of international law and why they matter to them. To the individual, wherever they may be. Those webcasts remain available. We're building up quite a library of them. We're doing about every 3 weeks. And we hope that if you haven't sampled them, you will do so. You can find them at our website, www.acil.org/100days. We may change that after the first 100 days, which are about to expire. And we may call it the second 100 days, or we may call it what next. But please continue to support those programs and to share them with your friends and your institutions. Now I'd first of all like to thank the ACIL annual meeting co-chairs, and particularly Julie Mopin, who is here. Julie, would you let people know who you are? They coordinated not only the entire meeting, but in particular these special sessions that we're presenting on these 3 days. I also would like to thank our longtime partners, CG, the Center for International Governance Innovation, for their sponsorship of this special series. And I'd like to introduce our colleague and friend, Una Fitzgerald, who is the director of CG's International Law Research Program, to make some brief remarks before the panel begins.
Thanks very much, Mark. It's a pleasure to be here. Good morning, everybody, and thanks for joining us for what promises to be a very interesting session on international law and the Trump administration, trade and investment. It's a real pleasure for the Center for International Governance Innovation to sponsor this panel. We're a nonpartisan, independent think tank focused on global issues of governance, law, politics, security, and economics. So I'm particularly pleased to see this exciting panel where we have not only lawyers, but economists and all kinds of different expertise to discuss this important topic. CG is based in Waterloo, Ontario, and we have fellows all around the world and working on issues of international economic law, international environmental law, intellectual property law, and Indigenous law and international law. Yesterday when I introduced, I mentioned a couple of sayings that we have in Canada about the close relationship we have with the US. And one is the metaphor of the sleeping with an elephant. In the area of trade, it feels like the elephant has not just grunted and twitched a little bit, he's rolled right over, and things are really changing in this domain. So we're really at a critical point in the international trading system. We've seen the popular distrust has been growing in investment issues as well as in trade. Canada had quite a rough ride with the CETA agreement with the EU, and it's still working its way to final ratification. And we've seen the Brexit vote, and now the U.S. election, and of course the Trump presidency, all posing all sorts of interesting issues for trade. We've seen how trade has really benefited capital, multinational corporations. It's allowed them to arrange their intellectual property, taxes, and labor for maximum advantage. But we know that some people have been left behind by that, and they seem to have risen up in many of the elections lately and referenda. So what next? Do we give up? Or is this an opportunity to look for something different? So it's either protectionism or reform. And this may be an opportunity to think about such things as inclusive trade. How does one include the Sustainable Development Goals within the trade and investment system? How do you include more women in trading, small and medium enterprises? How do you engage Indigenous people and subnational organizations? So I think there's a lot to discuss today, and I'm really looking forward to this. Thank you.
Thank you, Ona. And without further ado, let me introduce the moderator for today's session, Gary Huffbauer, who will take it from here.
Thanks. Let me just check first that you can hear me. Can the people in the back hear me? You cannot. You cannot. Well, I'll try shouting a bit louder. How are we doing now? Better. Okay. Well, we'll all try to shout directly into these microphones. So I'm Gary Huffbauer with the Peterson Institute. On my immediate right is Michael Smart with Rock Creek Global Advisors, which gives advice to companies all over the world on trade and investment issues. To his right is Warren Moriyama, former general counsel of the U.S. Trade Representative and now with Hogan Lovells, a very well-known firm and a very well-known person. To his right is Rachel Brewster, now a professor at Duke University, professor of law at Duke University, previously a colleague of Warren's in the U.S. Trade Representative Office. And on the far right is Aditya Matu, who is extremely well known in WTO circles and in the World Bank, where he now works as if not the leading expert, one of the leading experts on services trade in the world economy and generally on international trade. So he's an economist, Michael is an economist, I'm an economist, and we have two lawyers in the middle. So I guess where they should be. So the way we're going to try to run this little panel is, firstly, Aditya is going to speak. He's with an international organization, the World Bank. He doesn't want to get involved in U.S. politics for obvious reasons. So he is going to give us a background on the backlash against globalization, which everybody here is well aware of, and what might be done to revive a spirit of international cooperation. After that, I'm going to field questions to the panelists, and they'll all answer each of the questions, but I'll choose a lead panelist to start off on each of them. And we expect to have a good 25 minutes, 30 minutes at the end for questions, comments from the audience. So we hope that at least we provoke something in this very interesting time. So Adidas, please lead us off.
Thank you very much, Gary. Thank you for inviting me today, Judy. I'm going to make 4 quick points. First of all, that the backlash has a certain sense of historical inevitability, but it's fortunately very narrow in scope. Second, that it's not just against trade, which is a conventional wisdom, it's also against misplaced redistribution.
Oh my goodness.
Third, that if we are going to aim for more inclusive growth, in the sense that Unag spoke about, we need more, not less globalization. And we also need more, not less international cooperation, but it'll need to take new innovative forms. First of all, just one historical reference. Through most of the 19th century, when Britain was globally dominant, you might have expected it to trade on preferential exclusive terms with its colonies and with other countries. It didn't. It was a paragon of free trade imperialism. And for the most part, trade followed non-discriminatory MFN principles. It's only when Germany and the United States caught up towards the end of the 19th century and the beginning of the 20th century that Britain abandoned this free trade and non-preferential regime and reverted to, for example, the famous imperial preferences. So perhaps there are these century-long cycles in trade policy, and the United States in the post-Second World War economy was again the bulwark of multilateralism and played mostly by MFN or non-discriminatory rules, and it's the catch-up of China that has now induced this relatively, how should I say, I don't want to say protectionist because it hasn't reverted much to protectionism yet, but at least a greater emphasis on bilateralism. Now, for the most part, when you think about globalization, it has been a force for growth, the reduction of poverty, and global inequality. Over the last 30 years or so, the share of trade, goods trade in GDP increased from about roughly 1/3 to a half. Average incomes across the world grew by 24%. The poverty declined dramatically, the headcount from about 35% to less than 10%. And the incomes of the poorest 40% increased by 50%. So most of the world today is celebrating globalization. It's in this narrow Western segment, and in particular the Anglo-Saxon Western segment, that you've seen the strongest backlash. And there are good reasons for it, because it is true, and recent evidence convincingly demonstrates that globalization has had an effect on inequality. Regions where manufacturing was concentrated have been hit hardest in terms of employment and wages. Now, that's what was happening. But in many ways, when you think of the policies of the Obama administration, and this is as far as I'll go in terms of talking about US politics, they were classical prescriptions. The size of the cake was being maximized by choosing, by and large, open policies and pursuing trade agreements which should have led to greater openness. And at the same time, there was an effort to ensure that the gains from globalization would be distributed more equally. Whether it was the bailout of the car industry, whether it was the Affordable Care Act, or minimum wages, or cheaper college loans. So it's a puzzle. Why did voters reject this economically optimal package of maximizing the cake and distributing it more equally? And I think part of the reason is the way redistribution happened. Let me show you one picture. That is a picture of US counties. The darker colors indicate the counties where you saw the biggest shift from the Democratic to the Republican vote. So as you notice, a lot of it is concentrated up there in Michigan, Wisconsin, in Pennsylvania. Now let me show you another picture, and this will show you a picture of where people were already well insured. They had good access to health insurance. So the lighter colors are the counties where you had pretty good health insurance to begin with. And this is work in progress, but you see a striking fact that the switches were strongest where people were already well covered by a social safety net in terms of health insurance. And that points to a key aspect of what happened under the Affordable Care Act, that it was essentially a cross-subsidization scheme where the burden of higher premium was felt most in proportionate real terms by the income groups who were just above the subsidy entitled threshold. So a lot of this expansion and care came at the expense of the middle class. And that is the central point that I want to make, that the redistribution burden, and I'll give you another example in a minute, has fallen disproportionately on the middle class. So the backlash is not just against globalization, it's also against misplaced redistribution. So what is the solution? Now, when you think of, for example, the cost of healthcare, which is one of the biggest and central problems that we face, what would reduce it? And I think research we have done shows very convincingly that greater globalization, for example, of services like healthcare, would lead to dramatic reductions in costs. And whether it is by allowing better access to Filipino nurses or, Indian doctors, or whether it's by allowing greater portability of health insurance so that people can exploit the same huge gains from trade that we have seen in other areas, is something that we need to explore much more closely. But there is undoubtedly great scope for reduction in health costs through greater globalization. In goods trade, Feilbaum and Khandelwal have shown something really interesting. When you look at the bundle of consumption, if you were to shut off all trade, the richest people would lose purchasing power by about a third. But the poorest 10% would lose purchasing power by 2/3. So in a way, access to foreign goods disproportionately benefits the poor because their consumption patterns, especially in the United States, are oriented towards imported goods. So there's no question that there are big benefits to be had from further globalization. But there is a problem. And one of the problems we face is that perhaps the reason this redistribution has taken the perverse form of unduly punishing the middle class has to do with globalization itself. Very interesting work by Peter Egger and others has looked at the structure of taxes in countries. And what you see is quite striking. Those red and green lines reflect the tax rates on the top 1% and the corporate tax rate, I said this in reverse, in about 65 countries. And there's been a striking decline in these tax rates over the last 30 years. And instead, what has happened, that the tax rates on the median worker, the middle class, has actually increased over the period. And what is very nice about this work, it asks the question, how much of this is politically driven and how much of it is actually evidence that national tax regimes are disproportionately hurting the immobile middle class and progressively lightening the burden on capital and skills who can escape to other lower tax jurisdictions. And their evidence suggests that that increase in tax rate might be as much as 1.5% on the middle class and a lower tax rate of at least 1.5% on the higher income groups. That is the part that they think is directly attributable to the pressure of globalization. Now that raises the question, if we are going to cooperate internationally, should we stick to the old mechanical reciprocal liberalization, which really seems to have run out of steam? Or should we focus on these areas? For example, international taxation policy. Gary knows more about this than anybody else. But for example, a lot of tensions that are being seen today about the perceived asymmetric treatment of indirect taxes and direct taxes cry for greater international coordination and cooperation so that we don't have this race to the bottom in tax regimes. And that is an example of where I think greater emphasis needs to be in international cooperation. But more generally, when you think of the world as it is, and this is the last point I'm going to make, you can think of the current period as an age of insecurity. There is a range of concerns, whether it's about health and safety standards, whether it's about digital trade and informational insecurity, or about financial internationalization and what that does to financial instability, about people moving and security. And all of these are inextricably linked to trade. And the problem is that the conventional you open your markets and I'll open my markets way of negotiating doesn't really address these concerns. We need to think of new ways of international cooperation which take this legitimate concern about what globalization does into account. And what I would suggest is we need a different approach. The conventional approach has really been a negotiation of I'll open my markets and tie my hands against future protection if you do the same. People have talked about regulatory cooperation. But I would suggest that we need to think of new ways in which exporting countries can provide regulatory reassurance to importing countries in return for openness. And just one example of how this might work relates to data flows. You know, data flows between the European Union and the United States could have been completely cut off. And even now there is a Damocles sword which hangs over them because the Europeans said that our privacy regulation is not adequately respected in other jurisdictions, especially the United States, which has relatively lax privacy regulation. The solution was a bargain. It wasn't a trade bargain. It was a bargain between the United States and the European Union, where the United States didn't raise its own privacy standards. It just promised to adhere to European standards for European consumers. And that happened under what was first the Safe Harbor Agreement and then took the form of the EU-US Privacy Shield. That's the best part of the TPP agreement, and that's the part we shouldn't lose. It created obligations to allow data to flow, but it also imposed unprecedented obligations, which you as lawyers will understand better than I do, on exporting countries to protect foreign consumers from fraud and privacy. How that's going to be enforced, I think, is one of the most interesting questions. But in principle, that's the kind of international cooperation I think is needed to preserve openness. Thank you.
Aditya, thanks very much for that terrific start and stage setting. So the first question I'm going to toss out is the question whether Trump has now entered a go slow phase on trade policy. China is no longer a currency manipulator. The administration has not yet given Congress formal notification of NAFTA renegotiation. We have a 100-day agenda for negotiations with China on a variety of undisclosed issues, but all trade issues, trade friction. So there's a very different set of happenings than we heard in the campaign about disastrous trade deals and so forth. So to start us off on this question, I'm going to ask Warren Murayama to give us a start, and then the other Michael and Rachel to follow on with their observations. I have to correct what I said right at the beginning. Michael tells me he's actually a lawyer. He had fooled me. I thought he was an economist. Okay, Warren, over to you.
Well, thanks, Gary, and thanks to the American Society of International Law for convening this panel. And I guess we should also thank Donald Trump, because whatever one may think about his policies, he's been great for trade lawyers, trade professors, trade consultants, trade experts, and even tax people who never had the time of day for us trade types, and I'll have to listen to us go on and on about these obscure parts of WTO law of regarding border tax adjustments. We're just as incomprehensible as my tax return. I think Gary's question is a good one, and I think it is accurate, because whatever Trump's provocative America First trade rhetoric on the campaign trail, his actions so far have been comparatively restrained. And I would put this down to some of the realities of being president of the United States and sitting in the Oval Office starting to sink in. Because when you get there, just from my low level experience on the White House staff, I think what presidents and most people in the White House realize is that the reason you get to be president is because there are a lot of tough decisions, and the reason they're tough is there's no good option. And I think with Mexico, you've seen a major pullback from the idea that NAFTA was the worst trade agreement in the history of trade negotiations. As Gary pointed out, they haven't actually notified a NAFTA renegotiation. The idea of a 35% tariff on US companies has been scaled back, except for beating up on Ford and Carrier, and really not that much has happened there. If you start parsing carefully the administration's draft notification, which was circulated by USTR a couple of weeks ago, it's also comparatively restrained. There's some things in there that are going to be very interesting, like eliminating Chapter 19's binational review of anti-dumping and countervailing duty decisions, although that's probably a non-starter for Canada. And there's this sort of cryptic reference to equalizing tax treatments, which presumably is his complaint about Mexico's VAT rebates. But a lot of it seems to consist of incorporating various non-controversial chapters from TPP. And you find the same thing with China, where even though China was supposed to be raping and pillaging our country and the worst trade deals ever negotiated by our US trade negotiators, again, the idea of a 45% tariff on Chinese goods, I haven't seen that for several months. There was no designation of China as a currency manipulator, and he just told the Wall Street Journal that he's not going to designate China as a currency manipulator. And then you had this sort of love fest down in Florida at Mar-a-Lago with President Xi, where the main outcome seems to have been a 100-day negotiating exercise, which looks like the traditional technique in trade negotiations of just kicking the can down the road. There will be a day of reckoning at the 100 days where they will need to come up with something. But I think part of this is realities, which is North Korea has appeared for some time to be on the verge of developing an intercontinental ballistic missile that could launch nuclear warheads or chemical weapons at the west coast of the United States. And at that point, getting into a fight with China, which is probably the only country that has any leverage over North Korea, we don't, may not seem like the best use of American priorities. The other thing that's kicking in here is politics. And to some extent, Trump's America First trade agenda involves some real contradictions within the political constituency that put him in the White House, which is first rural counties, where he won just about every rural county in the United States, often by overwhelming margins. And the other is blue-collar workers, as Professor Mathieu pointed out, in some of these northern industrial states. My wife and I rent this small cottage on the eastern shore of Maryland. And if you drive down Route 50, drove down Route 50 last November, it was basically a forest of Trump-Pence signs. But if you also looked out there, it was also fields of soybeans, corn, wheat, and sorghum, large parts of which are exported to China. Mexico and China are our two biggest agricultural markets, and the ag community has always been very effective and has really, as you could see from Ambassador Lighthizer hearing, beating up on them about not messing up either NAFTA or the China relationship. So I think these are realities taking over. You're going to see probably some more restraint. On the other hand, you know, Trump seems very unpredictable, and he's going to be under some political pressure to deliver for his blue-collar base. So who knows what's going to come out of this down the road. Hopefully it lasts for a while and keeps us trade people in business.
Rachel, what's your crystal ball tell us?
So I agree with Warren's comments, particularly about driving students and reporters to trade lawyers' doors. I think that we're all in the trade community seem to be breathing a bit of a sigh of relief, a hesitant sigh at the moment, that China's not going to be labeled a currency manipulator, that the NAFTA, we have not withdrawn from NAFTA. But I also don't want to overemphasize the go slow. I mean, one of the first acts that Trump did was withdraw from the TPP negotiations. And I think that the loss of TPP is a mixed bag for the United States. I think that there was certainly a lot of criticism within the United States of the TPP negotiations, and it's not clear that a Clinton presidency would have been a strong supporter of that. But I think that there are definitely some opportunity costs for the United States going forward in trade negotiations. The fact that the US has basically withdrawn from being interested in negotiating trade agreements rather than just basically trying to renegotiate the agreements we already have, I think is a real loss in leadership. And I think that particularly in Asia, there's a feeling that there might be more of a Chinese willingness to take on some of that leadership. Certainly the Chinese are trying to expand some trade agreements through ASEAN, but I don't even want to overplay the idea that now China is going to, through a trade agreement, dominate Asia. I think that what might be happening during this period is just a shift in the center of gravity politically, right? That as a lot of particularly Asian countries, or countries on the Pacific, I should take that back, a lot of in the Americas as well, as a lot of countries who are on the Pacific kind of think about their trade options for the future, it seems like there might be countries other than the United States who are going to be the people who want to enter into these agreements, who are going to be offering the opportunities. And if there's a desire for liberalization, that the United States might not be the best partner right now. And I think that those are real opportunity costs for the United States. I mean, I think that it most clearly plays out in intellectual property, but which is a topic that, quite honestly, I'm a little bit ambivalent about. But I mean, I think that in terms of traditional US trade priorities, I think that the idea that right now we're dodging a bullet might be overselling it. I think that there's going to be less obvious, but real shifts in, let's call it momentum, in terms of trade liberalization.
Okay, Michael. Well, is there going to be enough chaos and tension to keep you in business?
More than enough. That's the silver lining, of course. But you know, I think the answer to your question, Gary, at least as it relates to trade negotiations, is emphatically yes. We're in a slower period than the administration anticipated. I mean, I don't think the explanation is that different from healthcare or tax or Syria, or I mean, it's just a lot more complicated, I think, than the administration realized. I was told that when they returned from one of their first Hill briefings on trade, one of the briefers remarked, "Who knew Congress cared so much about agriculture?" A point that Warren made, and that's really just the tip of the iceberg, because you know there's many things on the agenda. I guess I would also say that I think that it's less about sitting in the Oval Office and kind of reconsidering the issues than it is responding to external pressures. I mean, I think that they really ran into a bit of a wall with Congress. The notion that you've really got to kind of pre-negotiate a lot of your objectives with your partners before you can seriously begin a negotiation and hope to succeed. I think they're seeing that pushback, and hopefully it's influencing reconsideration. But I'm not yet an optimist on that front. Just logistically, it's also worth remembering that here we are, April 14th, and we've got a lot of key players missing from kind of the administration's, the folks who will be responsible for trade. I mean, the most obvious one is the USTR nominee, but certainly at the deputy and assistant secretary level below that, at USTR Commerce and State, a lot of the players are not in place, and without them, it's very hard to carry forward a substantive agenda. I think we'll continue to see executive orders. Won't be a great deal of substance to them, but on the particulars of trade negotiations, certainly the timetable has slowed. Longer term, I think the timetable has slowed for a reason that I think Rachel mentioned, which is that the U.S. has a bit of a credibility problem now. I mean, we led the TPP negotiation, persuaded parties to take on very difficult commitments while not doing a great deal on our own. We are an open market in general, so that's to be expected. And then everyone was left at the altar. And I think even the Trump administration kind of responded to that by saying, wait, we like bilateral arrangements. We want to do something with Japan, Vietnam, Thailand. Actually, they had a pretty long list. I think some of those countries are interested, but I think they're understandably going to take a wait and see attitude. And certainly they want NAFTA to be the test case to see how the administration handles that. As Warren said, there are reasons to think that many of the items on the agenda could be agreed fairly quickly because they were already negotiated in TPP. But if the administration is insistent on those more difficult issues, in addition to the ones that Warren mentioned, I'd point out government procurement, where really the points say the U.S. wants to restrict access to its market and more access to Canada and Mexico. I wouldn't want to be the lead on the government procurement chapter. I think that would be kind of a difficult thing to do. But so we'll see how that goes. If it goes well, then maybe this bilateral agenda can unfold. But in any event, I think the timetable will be slower than first anticipated.
Thanks. Okay, to my second question, I'm going to ask Rachel to lead off. The National Trade Policy 2017 document stresses U.S. sovereignty when it comes to decisions by the WTO appellate body. So in pending cases where the United States is the respondent, Rachel, do you think the U.S. will simply reject adverse findings? And what about cases where the U.S. is the petitioner? Will, if it doesn't win in the WTO, will it nevertheless resort to self-help under Section 301 or another statute? So, Rachel, tell us about the dispute system.
Well, this was a topic that about a month ago, I think I was fairly hyperventilating about. You had a lot of statements coming out of the White House, presumably on background, saying that the United States was just interested in going around the WTO dispute settlement, at least with regards to China, with regards to Mexico, possibly with regards to South Korea. And while going around the WTO sounds like just a very innocent stroll away or a different path, I think that, in fact, for the WTO system, this is something that is quite momentous. I mean, the WTO system continues to be the major trade agreement. I mean, we talk about regional agreements, but it is the multilateral agreement. And as everyone knows, the Doha negotiations are gone, and there are no trade negotiations on the horizon. And the dispute settlement and the idea that there is a rule-based system at the WTO for resolving disputes and for keeping trade relations understood is right now the lifeline for the WTO. I mean, that is the heartbeat. And the idea that the US would want to walk away from that, I think, is a really momentous issue. First off, I think that it's not necessarily a good policy move. I mean, if you're having a trade dispute with another state, such as China, someone else who is a large economy, and you say we have rules about this, but we're moving away from our well accepted and perceived as legitimate dispute settlement, and we're now going to move on to one-off negotiations. I think that the idea is generally because you don't think the rules are on your side. And so the idea that the United States would try and renegotiate issues with China bilaterally outside the WTO and then threaten to use Section 301, which is just kind of unilateral trade sanctions if we weren't getting our way, I'm not sure is going to be perceived internationally as particularly effective or legitimate. Certainly it could lead to things like trade wars, right? So if we do it, then other states can do it. But I think that it also then starts to really break down the international rule of law system at the WTO. Once the United States walks down this path, then other states are also free to walk down this path. So I don't think that it would be particularly effective for the Trump administration to do, but I also think that it's going to have really grave consequences. The WTO agreements, I think, are overwhelmingly in the United States' economic interests, right? We generally are an open economy. The WTO generally requires other states to adopt rules that push it in the open economy direction. And the WTO dispute resolution system has really empowered the United States. So unlike some other international courts, the U.S. was not dragged kicking and screaming into a rule-based adjudication at the WTO. The U.S., together with Canada, really pushed for this at the WTO. We wanted to move away from unilateral sanctioning because we thought generally the rules were benefiting us, but when we unilaterally sanctioned people, it was just seen as being a bully. And so the U.S. wanted rule-based dispute resolution at the WTO, so there would be a neutral mechanism for determining what the rules were. And then if the U.S. was going to use sanctioning, it would be specifically authorized by the WTO. And overwhelmingly, that is how WTO dispute resolution has worked. It's really empowered American interests. I think trying to move away from that because of what I think the United States sees as kind of minor losses at the WTO, which is largely having to do with the level of discretion and anti-dumping rules and some disputes about countervailing duties. I mean, these are really things at the margin. And when you look at the whole of the WTO and how well the dispute resolution system has worked, it seems like a relatively small reason to try and step away from the dispute resolution system. I think that the maximum effect of the WTO system, as in most legal systems, are the cases that are not brought. The actions that states don't take because they know there is a dispute resolution system. So even looking at the current win-loss rate at the WTO, I think, doesn't do justice to the U.S. interests in keeping the WTO system going and the damage that trying to walk away from that could do.
Thanks. Warren?
Well, I would agree with Rachel that some of the statements that were in that trade policy report that was issued by USTR a few months ago are very troubling in, if they're a signal of what the administration plans to do on WTO dispute settlement. You know, WTO, as we all know, is a huge breakthrough in international law. It's really made the GATT and WTO systems into a real set of international rules that govern global trade as opposed to a set of pieces of paper like a lot of international treaties that are widely ignored. And it has provided major benefits to the United States. We've won virtually every offensive case that we've brought. Our problems have come, and this is why the Trump administration is fixated on it, in the anti-dumping and countervailing duty area, where just about every anti-dumping and countervailing duty issue that's gone up to the appellate body has been struck down. And so, you know, a lot of the people in this administration come from steel anti-dumping and countervailing duty circles, and that's where they're coming from on WTO. You know, and I would say if you step back from the dumping and countervailing duties, then roughly 90% of the decisions that have come out of the WTO system have been good ones. And that's a pretty good rate, at least from my limited exposure to the US courts. It's probably about the same there. The one downside is you can always ignore WTO decisions, and the US has ignored far more than our fair share. But the price is that you have to be prepared to face WTO sanctioned retaliation against your exports. And as Mexican trucking showed, our trading partners are very adept at figuring out exactly what will make us feel political pain and what will make members of Congress or presidents of the United States start to squirm. And so if we really go down this road in a big way under Section 301B, which is where we go unilaterally, and which the WTO has already said would be a WTO violation, we should start shorting things like aircraft and agriculture because they're going to be at the top of the foreign lists.
Michael?
Yeah, I'm going to provide just a little bit of a counterpoint, I think, to this, and I'm reflecting a little bit here my congressional experience. I mean, the concern that WTO panels and the appellate body in some cases have overstepped their authority, I mean, that certainly predates Donald Trump. It was at the heart of a pretty ugly dispute last year when the U.S. objected to the reappointment of one of the appellate body members they thought was guilty of some of this overstepping. I agree, it's completely related to trade remedies. Interesting, I looked this up. Of all of the WTO disputes that have gone to a final decision, trade remedy cases involve more than half. So it's like 72 out of 160. So I agree, in the big scheme of things, it's just one part. It's almost like agriculture. You can't dismiss it. I don't mean to dismiss agriculture. I just mean that it has significance beyond if you just look purely at the economics. That's certainly driving congressional concern. And so, you know, is this administration going to reopen Byrd Amendment, which anyway, all of these various anti-dumping and countervailing duty decisions? I don't necessarily think so, but if there's one case where you could expect this administration might disregard a WTO decision, it's certainly in this area. The one other point I would make about U.S. as a complainant, Warren's right. Our record is nearly perfect. Actually, according to USTR, this is 2015, they say that they brought 114 cases. They didn't win the core issues in 4 of those. So if Braden Holtby has that kind of record, the Washington Capitals should be doing well. But I think part of the reason is because I think the U.S. has taken a pretty cautious approach in bringing cases. I mean, it really wants to have a high level of confidence that it will prevail. And if you look back at Bob Lighthizer testimony before the China Security and Economic Review Commission in 2010, this was one of the areas he's critical of U.S. trade policy. He's saying we've got to be a lot more ambitious in the kinds of cases that we bring. He's talking really about China there using GATT Article 15 to challenge currency manipulation. I talked about bringing non-violation, nullification, impairment cases. He said we need to be more imaginative. Well, if the U.S. is, and we are not so successful, then do we act unilaterally? And honestly, if you just kind of look at what Mr. Lighthizer has written about, things Secretary Ross has said, I think that's certainly an area where you could see the U.S. depart or not be constrained by WTO rules.
Thanks. Well, Michael, I want to keep you on the hot seat here. Weak enforcement of anti-dumping and countervailing duty and other trade statutes really is a pet grievance of Commerce Secretary Ross and National Trade Council Director Peter Navarro, and, as Michael just said, USTR designate Lighthizer. So just looking now at the U.S. side of things, what's your expectation, Michael, of the trade remedy kind of outlook now, the agenda under the next several years?
Yeah, thanks. Let me just preface this by saying, Gary, we were all talking about topics that we really need to cover during this session. I said trade remedies. Gary said, you're right. Why don't you take that? I'm not a trade remedy lawyer. I'm just going to offer some general observations, get the discussion going, because this is an area that if you're thinking about trade policy in the Trump administration, you really can't ignore. Let me first kind of challenge the premise a little bit that the U.S. has been weak when it comes to trade remedy enforcement. As of Wednesday, the U.S. had nearly 400 anti-dumping or countervailing duty orders in effect. Those are tariffs on incoming goods. That's a 50% increase from 10 years ago and is roughly proportional to our share of global trade. We account for about 14% of global imports and about 13% of trade remedy measures. The WTO looks at different measures put in place by G20 members. The last full year that they have that information for, the U.S. initiated, I should say, more anti-dumping investigations and countervailing duty investigations than any other G20 member. So, I mean, I would take issue with the characterization. I think we're not reticent when it comes to trade remedies, but that doesn't matter because we have an administration who I think is committed to being more aggressive in this area. And, you know, it's not surprising. Secretary Ross at the Department of Commerce, much of his career, he's participated in enterprises that have benefited from trade remedy relief, whether in steel or textiles or other sectors. Of course, Bob Lighthizer has spent his career representing U.S. steel companies and other domestic industries who also depend on trade remedies. I think in the first couple of months of the administration, you've seen further evidence of kind of where they're headed. Interestingly, Secretary Ross had an op-ed in the FT recently. He was talking mostly about this executive order that was issued on the trade deficit and how to deal with that. But in that, he talked about when the Department of Commerce, quote, wins anti-dumping cases. And I thought, that probably didn't go through general counsel at the Department of Commerce because, you know, if you look at fact sheets that come out when these determinations are made, everyone starts with a bullet that says, this is a quasi-judicial proceeding. Well, okay. You know, in the same piece, he also talked about companies accused of anti-dumping practices as being perpetrators, maybe not intending to introduce a criminal element, but I just think it gives a flavor of where they're coming from. How do they do this? Well, the kind of the topic that has received the most attention is self-initiation. Normally, the Department of Commerce waits to receive a petition from domestic industry for relief. But they don't have to. Commerce rarely initiates these on their own, but that avenue is open to them. I think it's been rarely used for a good reason. I mean, you have an agency that is already essentially the investigator, the judge, the enforcer. Now we'll add prosecutor. And I think you start to wonder, is this then kind of out of balance, you know, between remedying unfair trade and making sure that we don't impose unjustified restrictions. You saw earlier this week in the context of an administrative review that they're going to basically employ a new methodology to deal with steel imports from Korea, one more favorable to domestic industry. On the Hill and at Commerce, a lot of attention on anti-circumvention, you know, either falsifying the documents related to the origin of the goods or transshipment. This is another area that's going to receive increased attention. Interestingly, we could see this in trade agreements as well, which is really ironic because the domestic industry historically has always said, don't touch trade remedies in FTAs, because we're always sitting across from an FTA partner who wants relief from what we do. Right, but in the NAFTA letter that Warren mentioned, trade remedies is prominent on the list of negotiating objectives. So we'll see how they might pursue that. What are the constraints? Congress in some areas is going to be a constraint on the administration's trade policy. Not here. The administration, I think, will be acting very much in concert with kind of where Congress is generally, including in legislation approved recently in 2015. Resources, I think, could be a bigger constraint, particularly when it comes to self-initiation. Developing these cases is very hard. Commerce doesn't have experience doing it, and their personnel are already pretty tapped out. Could be more so if some of the proposed budget cuts go through. What about the International Trade Commission? They're the agency that has to make a decision on injury. It's an independent agency, independent commissioners. I think if you talk to lawyers who represent respondent industries abroad, they would say ITC is not too much of a hurdle to overcome. They rarely fail to find injury. That actually could become more so when the Trump administration has the opportunity to fill 3 vacancies at the ITC. Will they, fill them with folks that kind of view the world the same way they do? Lastly, we've got the courts, the Court of International Trade, that will continue to operate as it has, along with the U.S. Court of Federal Claims. Then it comes to the WTO. To what extent will the WTO be a constraint on what the administration wants to do on trade remedies? And for this, I went back and I looked at Bob Lighthizer testimony. This is before the Senate Finance Committee back in 2007, talking about trade remedies. I'm just going to read a couple of these. He said in one case, one of the biggest threats to our trade laws is from the dispute settlement system at the WTO. The system has fundamentally lost its way, and the decisions being issued by the WTO are gutting our trade laws. He went on, rogue WTO panel and appellate body decisions have consistently undermined U.S. interests by inventing new legal requirements that were never agreed to by the United States. And lastly, he said the WTO has ignored the Uruguay Round mandate on deferring to national authorities and has instead engaged in an all-out assault on trade remedy measures. If we look at the various potential kind of constraining factors on what the administration might do in this area, I think there's reason to have some doubt about where the WTO figures into that.
Thanks. That was very complete. I'm very mindful of the time because there's a clock here that is huge in size. So, Rachel, can you give a less than 1 minute comment? And I'm going to then reserve Warren for the next and final question before we turn to the audience. So, Rachel.
I think I can keep it short and sweet. I mean, to some extent, it makes me so happy to talk about trade remedies just because this is politics as normal for trade. I mean, under any administration, we'd be like, harder, softer with trade remedies. Trade remedies, I mean, anti-dumping law and countervailing duty law are meant to address real things, right? Dumping and subsidies. But they're also discussed, particularly by economists, as steam escape valves, right? I mean, that they're there when you have people who feel like they're hurting and that they need some sort of response. To some extent, anti-dumping and countervailing duties are supposed to do that. And so if that is where all of this is funneled, if all of the Trump administration anti-trade discussion ends up going into stronger trade remedy actions, then that's very much coloring within the lines of current trade agreements. And I think that a lot of trade economists and trade lawyers, not that we're going to get ignored now, but that it's going to be much more kind of the world that we're used to. The one thing I always want to throw in is that the U.S. is not the only country who applies trade remedies. Other countries do the same thing, and there is reciprocity. I think that Americans often feel like, well, we don't dump, we don't subsidize, but it's all about the rules the state adopts for finding subsidization and finding dumping. And it's good to have the WTO policing those rules. China has become very interested in trade remedy rules and is using them against the U.S. India has become very interested in trade remedy rules. And so, this is a reciprocity game. And I think it's just important to keep that in mind for trade remedies as well as everything else.
Thanks. Okay. The final question that I'm going to pitch out is on the border tax adjustment, which is a central feature of the Ryan Brady tax plan, both because it raises $1 trillion over 10 years if we keep our trade deficit at $500 billion a year, and because it offsets value-added tax adjustments, which are seen by President Trump and some of his advisors as extremely unfair to the United States. So, given that background, it's maybe a little surprising that President Trump has waffled on the border tax adjustment, and important Republican senators are opposed to it. So, Warren, a couple of questions. First, will the border tax adjustment concept survive the congressional legislative process? And if it does, how will U.S. trading partners react?
Well, if I knew whether it would pass, I would be a tax lobbyist instead of a trade lawyer. But, you know, just from having dealt with trade legislation, usually what it requires is some level of bipartisanship. It's a vote counting exercise. And at least the trade votes like CAFTA and the 2002 Trade Promotion Authority Act that, you know, were basically pursued along a very partisan party line strategy were horrendous exercises which required throwing in some last minute concessions on socks to put one of them over the top. You know, the last big tax reform bill that passed was in 1986. It was a bipartisan effort with President Reagan, House Ways and Means Chairman Rostenkowski, and Senator Bill Bradley, and it had broad support. This one appears to be a pretty much entirely Republican proposal. And what it comes from is the Better Way proposal, which was when House Speaker Ryan and then presidential candidate Trump were sort of fighting with each other. And A Better Way was designed to show that the House Republicans had at least a positive agenda. And one of the elements was a big corporate tax cut from 35% down to 20%. If you do that, from a budgetary standpoint, either you've got to raise taxes on someone else, which is always horrendously unpopular, or you've got to balloon the deficit, which doesn't work for a good chunk of the Republican Congressional Caucus. So they came up with this border tax adjustment, which is basically an effort to try and take the U.S. Corporate income tax system, rejigger it a bit, and then cram it under the WTO's border tax adjustments exception. If you look at the language of GATT Articles 2, 1, 2, and 3, which refer to taxes on the product, it's pretty clear that something that's really an income tax, which I think this is, would not cut it in the WTO. It's certainly not something that a lawyer would take on a contingency fee. If we lose it, you'd have a WTO dispute that would, I think, be filed almost instantaneously by all of our trading partners, because we're talking about sticking them with a 20% tax on imports. And it would put the U.S., I think there are, 167 WTO members. It would probably be 163 to 1, and or 2 or 3. We probably could strong arm a couple of, U.S. Overseas territories or something like that into joining with us. But it would be almost everyone else against the United States. We would, I think, very likely lose it. Almost certainly lose it. If you talk to most of the WTO experts, the people who've said this is illegal are mostly tax law professors. And then you'd have effectively the mother of all trade retaliations, in which the foreigners would get to unload on whatever is the impact of a 20% tax on all of our import trade. And so you basically could kiss most U.S. exports goodbye. I personally don't think that this thing is going to pass. Maybe tax politics is different, but so far the Republicans have opposed it, or the Democrats have in line opposed it. It's extremely regressive because you'd be cutting taxes for corporations, but effectively sticking consumers who buy at Walmart with increased prices. A bunch of Republican senators have already expressed misgivings. And at that point, I think there are serious questions whether this thing has the votes.
Well, that's a pretty negative view. Rachel, where do you come out on this?
So the question of whether or not it's going to pass Congress, I mean, it's just it's tough to predict. I mean, right now, the Trump administration doesn't seem to have the best record in front of Congress on something that all Republicans until now have agreed on. You combine tax policy and trade policy, that tends to be kind of, mixing the two hardest things. But if we kind of just by fiat decide that somehow it could pass Congress, I mean, I think that I think it's of questionable WTO legality. I mean, I think that there are some arguments that it tries to imitate a VAT. But I think that if we were going to try and make that argument fly, then we really need to be working with our trading partners about discussing how this really works as a VAT tax and how this is going to be the American version of the VAT tax. And if we got sued at the WTO, I'm not particularly optimistic. It's possible we would win. Gary, one of your colleagues, Chad Bown, has estimated that I think the retaliation would be over $300 billion. But I don't think it's going to come to that. Gary, as you've pointed out, dispute resolution at the WTO can easily take 4 to 6 years. You then have the opportunity to change your policy. And so the US could certainly try this on for size. But I think that this is definitely something where if you wanted to take this seriously as a policy, then you need to have a lot of international negotiations with major trading partners about how to shape this to meet their interests as well, and particularly not to be discriminatory. It's hard when you're coming up with these programs and you need the votes to not throw in more deductions, things that US firms can deduct and foreign firms can't. And those discriminatory elements are both what really upset foreign governments and I think what would obviously condemn it at the WTO. And so I think that this is really, this is threading a very, very small needle, but possible.
Michael, what are you telling your clients?
Well, basically that it's probably only slightly premature to perform the autopsy on BAT because, I mean, at least as originally envisioned, I think there's not much hope. I mean, the opponents were very effective right out of the blocks. I think for quite a while, people were reserving the possibility that if President Trump swooped in, embraced it wholly, that he could save it. I think that changed after healthcare. If he was unable to persuade, maybe a dozen junior members of the House, he's not going to turn around 8 or 10 senators who have kind of now come out on the record against border adjustment. I mean, speaking of the autopsy, I mean, the supporters could have argued this one of two ways. They could have argued it the way the intellectual authors argue it, which is that no distortions on trade, exchange rates adjust, dollar appreciates, importers are no worse off. They didn't do that. And they didn't do that precisely because the president was their audience. They had to convince him. And so for him, what is the best way to sell this? This is something that corrects a historic disadvantage that the United States has faced in international trade, levels the playing field, makes imports more expensive and exports cheaper. Once they kind of did that, then they're wide open to the argument that Warren just made, that you're essentially taxing Walmart shoppers to not only create zero tax for big exports, but actually massive annual rebates that they would be eligible for. So I think as envisioned, it's not going to advance, but I would say that this space, there will be something. There's still money that will be needed to pay for tax reform. There is strong support for going to a territorial system, and that's actually bipartisan. And then you've got to figure out, well, what do you do to prevent the base erosion and profit shifting? And that's what border adjustment was meant to deal with it. If we don't do it this way, then there has to be some form of replacement.
Thanks very much. We have 20 minutes now for questions from the floor. I see there's at least one microphone. Oh yeah, the microphone over here. Maybe there's one. Yeah, there are 3 microphones. So please identify yourself and ask a nice pointed question, and we'll try to get some answers. Please.
I'm Barry Appleton. I write some books about NAFTA, and I thought maybe we might talk about NAFTA with the panel just for a moment. I agree that everyone in the world is actually looking at NAFTA as a test case for what's going to go on. And of course, NAFTA is really, it can be done two ways. It's a regional agreement, but it actually is two sub-agreements. I just wonder what the panel has to say about what NAFTA is going to look like.
Thanks. I'm seeing people line up. So what I'm going to ask is I'm going to identify a person to answer the question on the panel, and I'm going to take a few more questions so we can get more in. So for that question, I think I'll turn it to Warren, please.
Well, I think.
Oh, no, but hold on. We get some more questions up here, Warren. I think I'll take this person over there.
Hi, Julian Arado at Brooklyn Law School. Thanks very much for the panel. So you guys have talked a lot about how the administration's preferences seem to be potentially reopening some of the older debates, but I'm curious about moving forward. It really struck me that, quite surprisingly, some of their documents seem to suggest that they're back to, even though we're going bilateral, not multilateral anymore, the deep integration agenda is back on the table. SPS was listed, TBT, renegotiating things like that through the bilateral form. And I'm just curious if you think this is serious or just it's on the list of topics for some reason that can't be explained. When you mentioned Lighthizer comments, it really struck me that this would be awfully surprising, that we would go back to requiring states to base their regulation on science and risk assessment. I mean, if the problem is overly aggressive interpretations of WTO norms, you know, that's one area where the appellate body has pulled back. So I'm curious if you think this is a serious approach or just verbiage.
Okay, Rachel, that will be for you. And this gentleman over here.
Mark Wojcik from the John Marshall Law School. The United States sells 28% of its corn to Mexico. Mexico, back in February, started organizing buying trips to Argentina and Brazil to buy corn from there instead. I wonder if these reactions of our trading partners have any influence on the policy discussions.
Okay, Michael, that's clearly up your alley. Okay, we'll start with Warren. And less than 1 minute, given the time.
I think it's still up in the air whether NAFTA would take the form of a single tweaking of the existing NAFTA or two separate free trade agreements. And, you know, with Lighthizer not on board yet and him being the, at least according to Senate Finance and Ways and Means, the lead negotiator, I think that's still very much an open question. One thing to point out, though, is that if this deal involves any changes to U.S. law, it has to go through the Congress under the Trade Promotion Authority procedures, which means that Donald Trump would have to invest a huge amount of political capital in a tectonic congressional trade vote that will be opposed by a big chunk of his blue-collar base, which doesn't want a fixed, improved, or expanded NAFTA. It wants NAFTA to go away. You know, one question, I guess, that's out there is whether the administration would play chicken by withdrawing from NAFTA and saying either pass this thing or this new renegotiated agreement, or there's no NAFTA. But I think Wilbur Ross was quoted a couple of weeks ago as saying that no NAFTA is not an option, and that they would go forward with these changes, and then, you know, if they don't pass the Congress, then one would have to say that this would be a horrible vote for President Trump, particularly if it's next year, right before a midterm congressional election. Then the old NAFTA, which has, from my point of view, served the U.S. pretty well, would stay in effect.
Let me put in a brief advertisement for the Peterson Institute. We're going to be putting out within a month or so a kind of what a new NAFTA would look like and what would be good and what would be bad. Rachel?
I'm going to also jump on the NAFTA question. Just, I mean, I agree with Warren that I think that the
but you're supposed to answer the other question.
Yeah, I know. I'm a bad panelist.
Yeah,
and
okay.
so the, you know, I think the administration is really going to try and stay within the bounds of what they can do through executive action. And that is going to really limit the amount of things that they can do. On to the SPS question, being a good panelist. The U.S., so a lot of the discussion we're having about agriculture up here is highly related to SPS. So the U.S. likes the SPS agreement because we like the idea that our agriculture exports get to go around the world. And largely SPS deals with either things that could make animals or plants or humans sick, or, kind of themselves pests. And so the U.S. is really a fan of the SPS agreement in the sense that it really helps to promote our agriculture exports against other states who might want to say something is unsafe, but not have good science to back it up. Bilaterally, I can't imagine that we'd want to weaken the SPS. If anything, we'd want to strengthen it. And so I don't see that this as being, I think the U.S., I think that that's one of the few issues where, the status quo is going to be good with the administration.
Michael?
Yeah, and just to clarify, the quotes that I read from Lighthizer were strictly about anti-dumping decisions by the WTO. No reason to think he's not a supporter of SPS and some of the other agreements. The agriculture dynamic you described, the importance of Mexico as an export market for U.S. ag, I think is the single biggest moderating influence in the NAFTA negotiation, and I don't think there's a close second. It's hugely important, and it's corn, as you mentioned, soybeans, beef, rice, dairy, hugely important. These are folks who live in Trump country, represented by members who are by and large Republicans. Speaker of the House cares a great deal about dairy. Mexico is an incredibly important market. So at least for the NAFTA negotiation, and also, maybe even for the trade agenda writ large, the reliance of U.S. ag on exports is a huge moderating influence, especially now that prices are so low and farm incomes are well down from where they were a few years ago.
Thanks. Jennifer?
Jennifer Hillman from the Georgetown Law Center. I wondered if I could come back to the point that Aditya started with, and that is the issue of, if you will, income inequality or misguided distribution, as you put it. I will express my own concern that I worry that this issue drags down the whole trade agenda, and I worry that the United States is a huge outlier in this. And if you look at it from any one of the factors, I mean, how much money does the United States spend on long-term worker training? We're at 0.4% of our GDP, whereas everybody else in the OECD is 3 to 4%. If you look at the Gini index, I mean, we're getting close to 50 in terms of gross inequality compared to, again, the OECD countries in the 20s. So my question is there a way to directly link the issue of dealing with distribution, income inequality, to trade agreements? I mean, should there be some kind of a way to actually directly bring that in as part of a trade agreement?
Okay, I'm going to turn that one to Michael. That's a good one and a difficult one. This gentleman?
Josh Curlin from the Justice Department. I have a much more mundane question than Jennifer. You all mentioned a recent commerce determination concerning Korea, but what I don't think was mentioned was that there was a somewhat unusual letter that preceded that determination from Peter Navarro at the National Trade Council to the Department of Commerce that may or may not have impacted the department's decision. So I'm wondering if you can comment on that as a potential new precedent of how the administration might interact with the more technocratic aspects of the government's trade apparatus.
Okay, that'll be for Warren. This gentleman here.
Thank you. Thank you very much for the great presentation. Very briefly, so about the dispute settlement system of the WTO and the U.S. position. I guess the United States has not been so satisfied with the dispute settlement system. Not recently, but given the U.S. position in the DSCU amendment or the rules negotiations at the Doha round, it seems that the United States has not been so satisfied with the current system of the dispute settlement at the WTO. So maybe it's not just about the Trump administration or new trend of protectionism. So my question is it really structural? Is there any structural concern on the part of the United States, or simply is it just a reflection of domestic concern from time to time, ebbs and flow type of thing? Thank you.
Thanks, Rachel. That'll be you. And we'll take a fourth question. I think this will be the last one because the time is closing in.
Robert Brookfield, Canadian Trade Law Bureau. First, an observation, the border tax adjustment. I find it odd that people sometimes suggest that it might be onside the WTO. It seems so clearly to me a violation of Canada Article 3 and pretty clearly a violation of privilege subsidies, both import substitution, which gets mentioned less, and export subsidies. But my question is, for Canada, the trade remedies is obviously a big concern. There's right now what I would call an appetizer for the softwood lumber dispute going on in the WTO on supercalendered paper. One of the claims is a pattern of conduct by Commerce. So not just about that finding in that particular case, but also the pattern of conduct that Commerce has done more generally. I'm wondering if, and I would hope when, Canada wins that case, how you see the administration responding to a questioning of a sort of fundamental way that Commerce approaches trade remedies. Will they see this as a technical matter on one case that they're not worried about, or is this going to be something like zeroing that will make them go ballistic?
Okay, these are 4 great questions. I'm going to ask each of the panelists to summarize briefly the question, because 4 questions, there's a lot to keep in mind. The last one I'll give to Warren as well. Michael, we'll start with you.
Jennifer, I agree completely with your diagnosis of the problem, that a big part of what has complicated trade politics in the United States is the fact that we're trailing well behind in attending to the other domestic policies that are necessary to address anxieties about competition, global markets, et cetera. I think that a report came out earlier this week. It was WTO, World Bank, and I don't remember. But anyway, I think I agreed with the thesis of that report, which is that in order for trade to be more inclusive, yes, there has to be trade reform, but I think they're putting the greater burden on domestic policy responses, whether that's training, education, healthcare, retirement security, et cetera. So as to your proposed prescription, should we introduce the issue directly into trade negotiations? I would say emphatically no. It's very frustrating because I feel like people lose track of the evolution of U.S. trade policy, even over just the last 15 years, to address all of these issues. I mean, I was on the Hill during the 2002 debate on Trade Promotion Authority, and at that time, the debate was labor environment in or out, right? It was that, really, agreements had not even dealt with those issues. As of 2002, they were in, right? And then there came a debate about, okay, well, is it more than simply enforcing the laws that you have on the books? Or should it be, we need some international standards, some international rules that would benchmark practices in labor and environment to make sure the playing field is level? That's now in the agreement, right? And we've done things to address, the particular interests of small and medium-sized enterprises. We've now got a negotiating objective on anti-corruption. I worry that there's only so much a trade agreement can carry to address these concerns before they really become almost unnegotiable. And then, of course, to the extent you expand, then you, in some ways, attract more criticism that through these international agreements, we're inappropriately infringing on national decisions. So in the way I see it, we have reached, I think, kind of the maximum carrying weight for FTAs, but that doesn't mean that we shouldn't, focus intently on addressing the problems that you described.
Thanks. Warren, you've got a couple of questions?
The questions I got related to dumping and countervailing duties. And the first one related to sort of an unusual incident where Peter Navarro from the White House wrote a letter to the Commerce Department about some dumping investigation on Korea, urging them to not use, I think, Korean costs or prices for the calculations, but to go outside Korea and use external benchmarks, which is something we've been doing for a long time on China. Not to surprisingly, Korea blew a gasket about this and is probably, I think, on its way to the Geneva right now to file their WTO challenge. I think it's a very odd situation since dumping and countervailing duty cases are subject to the Administrative Procedures Act. There's not supposed to be political interference, at least in the White House I worked in and in subsequent ones, but apparently not this one. There were strict rules about administration officials getting from outside the Commerce Department getting involved in these cases. So if they did, they were at least much more careful about covering their tracks than sending a letter that got stuck into the public record. So I think this is a legal issue, and I think your colleagues in the Civil Division will have to devote a large section of their briefs to explaining exactly how this happened. On paper, I was not involved in the case, and actually I don't do dumping and countervailing duties except very occasional dabbling. I mean, I think if something goes fundamentally to a part of Commerce Department practice, it'll go through the full range of appeals and Article 21.5s and potentially, since this administration is going to be pretty tough on these things, all the way to an Article 22 retaliation. But, I would expect Commerce very likely would stick to its guns.
Rachel?
So thanks for the question about the DSU. I mean, I want to adopt Warren's statement earlier that, I think USTR and probably the US government more generally, traditionally with WTO DSU settlement, 90% good, 10% concern. And so there's no question that up until now, the US, both when trying to negotiate new rules and more controversially with the reappointment of WTO appellate body members has, we've been active. There's things that the US would like to change. They would say fix. And I think that the rest of the world has more of a view that reappointment of appellate body members should be near automatic to assure judicial independence, and the US is not signing on to that view. And that is creating tensions. I think that is still playing within the DSU system, right? You're making the suggestions, you're working for reform. I think, and it might be that the Trump administration ends up doing the same thing. That China's not a currency manipulator, the WTO is a great thing for the United States. But I think that at least some of the early statements coming out of the Trump administration were much different on the DSU. It was not so much that we have concerns and that we want to work within the system, but that, when we have disputes, we are not going to go through the DSU. When we have disputes, we are going to take them and we will use unilateral sanctioning without even filing a WTO complaint. That is just a different category. I even resist the continuum idea, right? And so I think that while there has been previous US concerns with the DSU, at least the early statements coming out of the Trump administration were just a different category of ways to deal with those concerns than previous administrations have adopted.
Warren wants 30 seconds, and then I'm going to ask Aditya to give any final closing thoughts he might have.
Yeah, well, and I was the general counsel when the U.S. put forward some of its proposals on DSU reform, and I would say that they were extremely limited. Because I don't think there's a systemic fix, and certainly going to the old GATT system where the losing party had to agree to adoption of a case, that's something that was a disaster for us, and particularly for U.S. agriculture and cases against the EU. I think the main thing that the U.S. has always tried to signal to the appellate body under Bush, Obama, and very likely under Trump was that you got to be careful about how far you go in some of these cases, particularly when they don't seem to be founded on the text or the negotiating history. And our problem with zeroing was that anyone who was in the negotiations, and I was there for the first 3 years of it, knows that there was never any agreement on zeroing. And there were also cases under the Tokyo Round anti-dumping code that upheld zeroing. So to sort of stretch various provisions of the text, even however much one may think that zeroing is an artificial concoction, and there's a pretty good argument that it was, you need to have something out there so that we could point out to Congress that there was actually a deal on this thing and it was WTO illegal. So I would say that the problem is not fundamental changes to the rules or any sort of a fundamental systemic fix. It's an exercise of judgment, and it's having good people on the appellate body.
Aditya, some closing thoughts?
Just two things. One, a lot of attention has been focused in the debate on protection. I think one big question which is elusive is why non-discrimination in the most favored nation sense is desirable, and why a hegemon, a large country, might actually benefit from playing non-discrimination. I think that is a more elusive notion, and why that is to the advantage of the United States, I think that's worth emphasizing, because in a sense, we don't just have the risk of protection, we have a risk of degeneration into bilateralism, the revival of Super 301. And why does that not make sense when it does have a certain intuitive appeal to try and bully individual countries into submission? And why should you choose to refrain from doing that? I think that is a challenge for all of us. The second question, and Jennifer always asks, I think, the most thoughtful questions, I would tend to agree with what Michael said, that I think there are, in principle, provisions like the safeguard clause, which do take into account, or could take into account not just injury to industry, but injury to worker and adjustment. And I am worried that if we were to bring in what is essentially a domestic policy issue like distribution into a permissible protection basis, that there are risks there. But I do think there are two questions worth thinking about more. There are sharp contrasts in this new report that we put out recently that Michael referred to between a country like Denmark and a country like the United States, of how they are able to, in a way, deal with social welfare and yet maintain a high degree of openness. Their adjustment assistance isn't just focused on trade, it also deals with technological displacement. And it isn't just focused on the workers that are directly affected, it focuses on all communities. And that is a question. Why is there so little meaningful political support for meaningful social support mechanisms which would more credibly help the United States to sustain openness? And here again, the one point I think is worth thinking about, it's a point that Larry Summers has made in different contexts, which is that maybe globalization itself is constraining the ability of societies to raise the revenues to provide assistance. And here the evidence that I presented does suggest, I don't know how much, and that's a question for all of you, how much is the US tax structure today a consequence of political vested interests, and how much of it is actually shaped by the fact that capital and skilled labor is mobile? I think that's a very important empirical question, but insofar as there is a compelling conceptual argument that national trade policies non-cooperatively lead to suboptimal things, that's also true of national tax policies. And there is a very strong argument for international cooperation on taxation. And there is a risk, I would say, that if we stick to this tunnel vision on trade policy, we already see the blurring of the distinctions happening already between direct and indirect taxation in national trade policy. And so I think if we are going to preserve the openness of trade policy per se, we need to see greater cooperation on tax policy in general.
Thanks for a great audience. Thanks for a great panel.
Definitely leading us on a high note.